It's a great privilege to address this gathering, particularly as the occasion is about honoring and celebrating Justice J.S. Verma, a man of the utmost probity and intellect. He imbibed an innate sense of leadership, and he displayed a remarkable commitment to our constitutional ethos. He has been described very aptly as the nation's conscience keeper and a luminary of the Indian judiciary. He is someone that I have always looked up to. His work continues to inspire us to restore our commitment to the rule of law and work in a manner that furthers the ideals of equality. I had suggested to Mr. Tanka that I speak on the topic Justice J.S. Verma, Reimaginations of the Indian Judiciary. I say so because there is nothing constant in any system. You have to keep on innovating if you have to go on, otherwise you will stagnate. And that's what Justice Verma did. Innovate in the legal space so that we get a better future tomorrow. The topic seemed natural enough considering the widespread social impact of Justice Verma's judgments and the judicial innovations introduced by him that we continue to rely on this date. I do not endeavor to present an appraisal of his contribution, as there is a multiplicity of writings on the subject already. Instead, I only want to contextualize some of his interventions, and I believe that is necessary to be able to present a more wholesome picture of how Justice Verma imagined our courts, our policy, and how the imagination furthered his commitment to justice, equality, and fraternity. I have always believed that our most effective judges are those who most confidently and comfortably straddle the exigencies of the present and the future. This is reflective of the inherent dynamism involved in the work of judges. First, judges must be very firmly rooted in the social milieu that they have emerged from and remain part of it. They must have an innate understanding of their contemporary realities. Second, they must be sensitive to the churn of social energies, to the new and upcoming ways of thinking that are likely to disrupt our present ways of functioning. I shall devote the rest of my address to the myriad ways in which Justice Verma was an exemplar of this dynamism. Justice Verma was one of those rare individuals whose impact went beyond the office he occupied and the times he lived in. His far-sighted contributions have proven to be a benchmark and a foundation upon which subsequent endeavors towards social justice have been launched from. His legacy persists with us to this date and enjoins us to work in ways that further our constitutional ideas. It would be apposite to begin with the most celebrated decision of them all, which is Vishaka versus State of Rajasthan. The petitioners in that case had approached the Supreme Court, claiming an increase in incidents of sexual harassment against women in workplaces across the country. They wanted the Supreme Court to be a forum which could highlight this issue, especially as it was felt that the state had been slow to respond on it. What followed is now well known. Justice Verma, speaking for the Supreme Court, evolved a set of guidelines for preventing and addressing sexual harassment in workplaces. The guidelines not only provided immediate succor for those who were vulnerable, but they also kick-started a lengthy and ongoing movement for a more comprehensive and inclusive set of guidelines for women in workplaces. The Sexual Harassment of Women at Workplaces Prevention, Prohibition and Redressal Act of 2013, which drew its lineage from the Vishaka guidelines, came to be passed more than a decade after this judgment. Vishaka is now aptly recognized as a symbol of judicial innovation. The Supreme Court boldly ventured into an arena where there was lacunas left by the legislature. Here, one must also make note of Justice Verma's judgment in Nilabati Behra versus State of Orissa, a case which concerned the custodial death of a young man due to injuries inflicted upon him by the police. The court held that contravention of fundamental freedoms could give rise to a claim in public law for monetary compensation, and that the court was empowered to grant the same under Article 32 of the Constitution. For me, these two judgments highlight the creativity, fearlessness, and farsightedness in Justice Verma's understanding of Indian polity in three important ways. First, the Vishaka and Nilabati Behra judgments underline Justice Verma's view of constitutionalism not as a static idea but as a larger movement. Justice Verma recognized the revolutionary potential of the text of Article 14, 15, 19, and 21. He understood the historical necessity of constitution making. It was a way for people to feel connected to their past, to their homeland, and to each other. He knew that the Constitution as a document came into being not in a vacuum, but as a part of other revolutions in Europe, South America, and Africa. Vishaka is a realization that the role of the judiciary is not informed only by a nation's extant norms, but by the social current taking place across the world. Thus, in formulating the Vishaka guidelines, the court heavily referred to the various international conventions against sexual harassment that India was party to. By doing so, Justice Verma placed India at the confluence of global movements towards greater access to justice and equality. Today, as we reach 25th anniversary of Vishaka's judgment, it is important to take stock of the progress made and the ways to go. We must reflect upon the ways in which impact of Justice Verma's decision can be amplified. We must acknowledge that the movement for gender equality still has some ways to go. As we are aware, sexual harassment at workplace continues to be a prevailing problem. It behoves us to work towards improving the Vishaka framework in order to address the various contingencies of today's day and age. In this regard, I would like to take this opportunity to highlight a few areas where our collective energies can be directed. In the 25th year following Vishaka, the socio-economic profile of our country has changed in multiple ways. There have been further changes brought about by the COVID-19 pandemic. In that respect, we must endeavor to rework our definitions of workplaces where sexual harassment can be said to occur. For many professions today, work is no longer constrained by the four walls of a physical office. Gig economy workers at times are required to visit the homes of their clients or to be constantly on the move between multiple venues. These can leave employees vulnerable in situations where the employer may not be willing or able to protect them. There is also a separate set of challenges when employees work from home over virtual platforms. Have been incidents of sexual harassment through video calls. Thus, to meaningfully safeguard the rights enumerated by Vishaka, we must contemplate the foreseeable ways in which laws can protect workers in such scenarios. Even within our traditional understanding of a workplace, there is work to be done further. The purport of Vishaka's guideline. There are many insidious ways in which women are targeted, and when they are seen to be challenging the traditional gender norms imposed upon them, sexual discrimination becomes a tool by which social position of a woman is reinforced. It thus degrades the work environment of a woman, which was the original problem that Vishaka set out to address. The ambit of Vishaka's guideline can also be expanded to capture the variation in the experience by different groups of people. While women are most common targets, the phenomena of sexual harassment can victimize other people as well. Men who do not conform to traditional masculine norms, people from the LGBTQ community, and gender non-conforming individuals are also targeted. The social objective of Vishaka cannot be attained if there are gaps in legal protection that create vulnerability to sexual harassment amongst a section of workers. In this regard, it is notable that Justice Verma continues to be held in high esteem by the LGBTQ community in the country. As the head of the News Broadcasting Standard Authority, he took suo motu cognizance against a program of a TV channel called Gay Culture Rampant in Hyderabad. Justice Verma observed in the program merely carried a gratuitous depiction and reportage of homosexuality among men without any underlying serious message for the society, and it violated the right to privacy of individuals with the possible alternate sexual orientation no longer considered taboo or criminal act, unquote. He also advocated for sexual assaults to be made gender neutral in his report on the amendment to the criminal law published on 23rd January 2013. Coming to the second impact of Vishaka, much like Nilabati Behra, reimagining the court as a broader public forum instead of a limited space for adjudication of disputes. This is also borne out from Justice Verma's introduction of continuing mandamus, an innovation that allows the judiciary to converse with other institutions and to be truly involved in the process of governance. Justice Verma understood the court's writ jurisdiction to be an open-ended outlet for groups that hitherto had no appropriate mechanism for redress. In this sense, he practiced Dr. Ambedkar's vision of constitutional morality, which sees in the Constitution not just a method to organize our political space, but as a source of a common language to be adopted by all citizens and institutions. This common language replaces outmoded mechanisms of social organization, such as rule by power, by one's wealth and social standing, and by exclusion. In this regard, I view Justice Verma was an active judge instead of an activist judge. Most of us all, he was deeply principled man. I am reminded of Justice Cardozo's quote that there is in each of us a stream of tendency, whether you choose to call it philosophy or not, which gives coherence and directions to thought and action. Judges cannot escape that current any more than other mortals. For Justice Verma, the current that he followed was his own principled commitment to constitutional morality. In a slight digression from my text, I would like to only delve shortly on what Chief Minister ji mentioned, which is about the problem of how women suffer on account of various societal norms and the violations in society. He mentioned an important aspect, which is that a large percentage of these violations come from within the house or with persons known. इसका सॉल्यूशन क्या है? हर जने को आप टांग नहीं सकते हैं, ये पॉसिबल नहीं है। और अगर ये पॉसिबल नहीं है तो कहीं ना कहीं हमारी जो सोसाइटी है उसके मंथन में से कुछ न कुछ ऐसा निकलना पड़ेगा जिससे लोग समझें कि ये चीज़ क्यों गलत है। पर हमारी सोसाइटी अभी मंथन में ही है, चेंज होगा। बड़ी एंशंट सोसाइटी है, बड़ी वेरिड सोसाइटी है ये, और इसमें सिर्फ जेंडर बायस ही नहीं है, अत्याचार औरत और औरत के ऊपर भी होता है। तो सास भी कभी बहू थी माना जाता है, क्यों नहीं होता है, क्या प्रॉब्लम है? उसको कहा जाता है कि ये एक मदर इन लॉ सिंड्रोम है। इट्स अ नॉर्मल कॉन्सेप्ट। मदर इन लॉ सिंड्रोम यह है कि जो औरत उसी हालात से गई है वो फिर नेक्स्ट जनरेशन के संग ऐसा क्यों करती है। ये उसी में नहीं, मैं और सोसाइटी के पार्ट से भी कहूँगा, जो कई सोसाइटी के पार्ट्स इफेक्ट हुए हैं, जो पीड़ित रहे हैं, जो इमर्ज कर रहे हैं, कई बार उनसे ही और लोगों की, उस कैटेगरी के लोगों की पीड़ा उत्पन्न होती है। तो ये एक सोसाइटी का मंथन है। कहीं ना कहीं 200 प्लस 600 800 साल के राज में हम लोगों की सोच इफेक्ट हुई थी। उस सोच को वापस आने में, उसकी एक इंडिपेंडेंट थॉट प्रोसेस को लाने में, उसको समझने में कि हम लोग एक बेटर सोसाइटी कैसे बना सकते हैं, इस पे डिबेट चलनी पड़ेगी। और डिसिप्लिन मेरी बिलीफ है एक इम्पॉर्टेंट पार्ट इसका है। जस्टिस वर्मा की लाइफ भी एक डिसिप्लिन का मोड था। एंड मैं समझता हूँ अगर सोसाइटी को रिफॉर्म करना है और वर्ल्ड की सोसाइटीज़ को आप देखते हैं जहाँ प्रोग्रेस हुई है, तो एक सेल्फ डिसिप्लिन जब तक हर जने में नहीं आएगा वो बहुत ज़रूरी है। कभी कभी मैं लाइटर साइड पे कहता हूँ कि अंग्रेज़ों से 3 चीज़ सीखने की थी। हम लोगों ने सब कुछ सीखा, वो 3 चीज़ नहीं सीखी। उन 3 चीज़ में पहली ये है कि सिर्फ प्राइड इन द हाउस नहीं है, प्राइड इन स्ट्रीट, प्राइड इन टाउन, प्राउड इन कंट्री, ये बड़ी एक चीज़ है। दूसरी चीज़ था उनका सेंस ऑफ डिसिप्लिन, और तीसरा था सेंस ऑफ ह्यूमर। कहीं ना कहीं हम ये तीनों चीज़ खो के बाकी और चीज़ों को अपनी ज़िंदगी में इनकॉर्पोरेट कर लेते हैं, कहते हुए कि ये हमने इनहेरिट करा है ब्रिटिश। कमिंग बैक टू द सब्जेक्ट, टू मी जस्टिस वर्मा's life is a testament to the pervasive power of principles. Constitutional morality encourages us to act in accordance with the principle instead of a strict doctrine. Principles guide our decision making, but unlike rules or dogmas, they are not open textured. They provide a direction which may have multiple paths. Principles celebrate the multiplicity of action and of being. We find that in today's heavily polarized world, there is less and less room for engagement. Instead of committing to orthodoxy of any nature, Justice Verma chose to repose his faith in more eternal principles of justice, equality, and constitutional morality. Third, it is important to highlight that Justice Verma's tenure in the Supreme Court lasted from 1989 to 1998. As we are aware, this was a highly tumultuous and exciting period for India as the country was in throes of economic liberalization. As economic considerations took over, Justice Verma's decisions recognized the dual character of globalization. Just as these forces would bring about an increase in opportunities and standards of living, they would also open up new ways of economic oppression. More and more women would be able to join the workforce, but there would be also need to safeguard against the oppression faced by them. At this critical juncture, the court was required to re-emphasize the state's role as the guardian of individual rights as enshrined in our constitution. I firmly believe that Vishaka and Nilabati Behra judgments are illustrative of this vision. In that sense, Justice Verma was the one who ushered the Supreme Court into a new millennium. It is his vision of the Supreme Court that redefined the role of the judiciary at the cusp of the 20th and 21st centuries. His work was forever reconfigured the role of judges as active participants in the project of good governance. Our country has had a storied tradition of judges contributing to public discourse beyond their position on the bench. Justice Verma also assumed a very proactive role in this regard. He headed the Commission of Inquiry set up to determine the nature of security lapses that led to the former Prime Minister Rajiv Gandhi's assassination in 1991. He submitted his report in June 1992. It was found that there were gaps in communication between the Intelligence Bureau and the central and state governments, and a dereliction of duty on part of the security agencies. True Justice Verma's nature, the report also carried a set of recommendations for the security infrastructure in the country. Justice Verma also gained further prominence and visibility as the bench of the Supreme Court, headed by him, was monitoring the infamous Jain Hawala case. This case had gained a public prominence after it threatened to expose deep-rooted nexus of corruption between politicians, businessmen, and investigative authorities. Justice Verma took this case up with his trademark crusading zeal. He forced the CBI to stop dragging its feet and to undertake rigorous steps for a detailed investigation of every single accused person in the case, irrespective of their political status. He even directed the CBI chief to attend every single hearing. He quoted Lord Denning in an order, observing that the Commissioner of Police, inverted commas, like every constable in the land, is answerable to the law and to the law alone, unquote. There was an expectation that the judiciary would stand up to the big wigs amongst the political and executive classes. In that process, Supreme Court became a symbol of hope for the common man. with the promise of an overall political cleansing and greater accountability. Just as Justice Verma was deeply concerned with issues related to good governance and polity at large, he was never afraid to turn the mirror towards himself and his colleagues. For him, equity and justice could not be propagated until and unless they were first practiced. Justice Verma had powerfully declared that self-regulation was infinitely more desirable than external interventions. In one of his interviews, he had words of advice for the institution that was so dear to him. He said, "Let us ensure that our behavior is impeccable so that no one can say anything." Justice Verma also confidently followed through his words. After he took over Chief Justice of India, he passed a resolution called the Restatement of Values of Judicial Life, which was unanimously adopted by the full court for the Supreme Court on 7th of May 1977. The resolution contains a code of ethics and serves as a guide for all judges today. It comprises of intractable principles pertaining to the independence and integrity of judges. The restatement certainly endows judges with a sense of heavy and somber responsibility, but I believe that it also enhances the prestige of the institution and the legal practice as a whole. Justice Verma recognized that judiciary's objective of doing impartial and complete justice must begin with fairness in dealing of the judges themselves. It was not just our country that regarded Justice Verma as a proponent of judicial independence and fearlessness. He was designated by the Malaysian government as an eminent person to review the 1988 judicial crisis in Malaysia. Prime Minister Mahathir Mohamad had sacked the Lord President of Supreme Court along with 2 other judges, and this move put judicial independence in Malaysia under serious jeopardy. Justice Verma's report found that the sackings were unconstitutional. The report thereafter led to judicial reform process in Malaysia. Justice Verma's contribution thus led many significant afterlives both in India and abroad. It is fair to say that Justice Verma's interventions are now embedded in the fabric of our judicial system. However, I also believe that he would caution us not to take them for granted, to not treat them as articles of faith, but as markers of social progress. Justice Verma, in his interviews after his retirement, acknowledged that systems themselves would always be fallible, that they could only be as strong as the individuals who are part of them. In this context, I now wish to turn to another of Justice Verma's judgment, which now more popularly is known as the second judge's case. The judgment of this court in that case led to the creation of a collegium system as we know it today. The majority opinion in this case entrenched and formalized what they considered to be the prevailing practice of appointment of judges. Among other things, the collegium system has been criticized for creating a veil of secrecy around judicial appointments. For those outside the system, it can be hard to decipher the criteria for appointment and transfer of judges. I too have believed for a while that there is merit in this concern. And perhaps the time has come to revisit the issue. If we expect our citizens to repose their faith within the judiciary, we must promote greater transparency in the administration of our courts. No longer can we let the courts be viewed as self-enclosed citadels. Just as with our public institutions, we must work towards imagining a better system. Such a system should preferably take into account the diversity in the social philosophies, gender, and social background in the appointment of judges. I firmly believe that such a system can be contemplated while preserving the independence of the judiciary. Just as we apply our various thresholds of judicial review upon actions of public bodies, I believe that there is reason for the judiciary as an institution not to impose high standards upon its own functioning. The task may be monumental, but I believe that with sincerity and determination it can be achieved. For example, when it comes to question of elevation, we can develop some objective threshold criteria to evaluate the performance of judges. This can include an analysis of the time taken to reserve and pronounce judgments, the pendency in one docket. The raw number, of course, may not give the complete picture, but they can be useful starting points for our inquiry. These interventions can go a long way in enhancing the trust reposed by the citizenry in the judiciary. I would like to end with a quote from Cicero, which to me exemplifies Justice Verma's extraordinary commitment to our constitutional ethos. Quote, "Justice looks for no prize and no price. It is sought for itself and is at once the cause and meaning of all virtues." Unquote. Justice Verma will always remain a wellspring of moral influence upon our judicial institutions through his courage, integrity, and character. Thank you. Jai Hind.
Thank you very much indeed, sir, for that motivating memorial lecture.